nobody in the back could hear anybody, so I'm going to speak up a little bit. One of the most popular initiatives we've ever done was the 1% cap on property tax increases, Initiative 747. It got 58% of the vote. It got over 200,000 more votes than the opposition did. It was incredibly straightforward. We crossed out the current limit number and replaced it with the number 1%. But the state Supreme Court ruled against it because of Article 2, Section 37, amending by reference. The court was emphatic. The text of 747 did not accurately set forth the act revised or the section amended and misled voters. The lower court judge said basically the same thing. The voters were misled as to the content of the law. The Constitution forbids this. This was a ballot measure that crossed out one number and replaced it with another. The court specifically said that it is irrelevant what's in the voter's pamphlet, what's mailed out to people, what's said on the floor. What matters is the text of the measure. And Sound Transit's legislation hid from the public the valuation schedule by not setting it forth in full. If the scales of justice were balanced, Sound Transit's deception would be found unconstitutional too. When 747 was rejected by the courts, the opponents were gleeful. Quote, "The Washington Supreme Court has sent a clear message. There will be no deception in the ballot measure process." The lawyer who brought the lawsuit said, "The court today confirmed that the Constitution protects voters from being misled. If the measure had been truthful, it never would have gained majority voter approval. If Sound Transit had been truthful and told voters that their car tab taxes would skyrocket because they drafted their bill to dishonestly hyperinflate the value of vehicles, it wouldn't have received legislative support or voter approval either." Since the election of ST3, Sound Transit has been blaming the legislature and the voters for not reading the fine print. But as this hearing has illustrated, the fine print of Sound Transit's bill was drafted to purposely mislead the legislature and deceive voters into approving a massive tax increase they never would have approved if the bill was drafted correctly and honestly. As Sound Transit's lawyers knew, voters have twice passed ballot measures to repeal this dishonest vehicle valuation schedule. They knew how much voters despised that vehicle valuation schedule. And after voters explicitly repealed it for the first time, the court said the voters didn't know what they were doing based on the measure's text. The court said it being approved by voters was irrelevant. So the court resurrected that vehicle valuation schedule. So a few years later, we sponsored a second ballot measure that also repealed this unfair, deceptive vehicle valuation schedule. And voters repealed it again, clearly and unambiguously. The Supreme Court upheld that initiative, rejecting the single subject rule concerns, etc. But nonetheless, the court again resurrected the deceptive valuation schedule. So despite voters twice saying no to artificially inflated car tab taxes, like a zombie in Walking Dead, it has survived and keeps plodding forward, terrorizing taxpayers. So it is no coincidence that Sound Transit's legislation purposely hid the vehicle valuation schedule from legislators and voters. The court has repeatedly said that voters need to be protected from ballot measures that mislead or deceive. ST3 is the most self-evident example of misleading legislation on our state's history. It was purposely drafted to deceive. This hearing is putting a needed spotlight on the Sound Transit industrial complex, as illustrated by the huge turnout of special interests here today that are benefiting from Sound Transit's ill-gotten gains. Would this intimidation and show of force be needed if Sound Transit's practices were defensible? Ripping off taxpayers was not an accident or an oversight. It is Sound Transit's modus operandi. It is their long-standing practice. Our initiatives passed by much wider margins than did ST3. And so for the scales of justice to be balanced, Sound Transit's fraudulent legislation needs to be held to that same exacting standard. This hearing is a positive step in that direction by exposing ST3's deceptions and highlighting how Sound Transit has ripped off the taxpayers for $54 billion for their own selfish gain. The most impactful story that I saw on this was Melissa Santos' story in the News Tribune, almost interestingly, on April 15th of this year. She quoted numerous legislators. A couple of paragraphs jumped out at me. The older formula significantly overestimated a vehicle's value in its first 10 years of life, leading to higher car tab fees. Quote, Sound Transit never mentioned that. They were intentionally vague and deceptive, said Majority Leader Mark Schessler about Sound Transit. Judy Cliborn, the chairman of the House Transportation Committee, said it hadn't even occurred to her that Sound Transit would use the older method to calculate car tab fees, which lawmakers long ago decided was unfair. Curtis King said, quote, I don't think any of us looked at the words that were in there. They were Sound Transit's words. Who elected Desmond Brown to the legislature? Is he a senator? Is he a representative? What the hell is going on here? The Tacoma News Tribune also said that at a committee hearing in 2015, Sound Transit board members repeatedly spoke of needing the legislature to authorize the quote-unquote full $15 billion in taxing authority. Cliborn, the House Transportation Committee chairman, said she's not sure lawmakers would have signed off on Sound Transit 3 if they had known how big the tax proposal would become. Quote, I think if you had said, we're going to bond this and we're going to ask for $54 billion, it would not have gone anywhere, Cliborn said. Nobody was going to do that. Everybody was having this $15 billion in front of them. I would close with, before I take your questions, that it's maddening, I think, to the average voter to be listening to legislators asking Desmond Brown about his bill and how he drafted it when the role of legislators is to draft legislation. It is not special interest groups and for people that are supportive of their side throwing them life preservers, trying to let them off the hook that, no, you meant to do that. No, this is okay. I think that's just a pathetic cover-up. And that what we have here is a really dangerous situation where the people who are getting the money are drafting the legislation. And because the people that are getting the money have every incentive to mislead the people and the legislature to get $54 billion they won't be able to get any other way is extremely dangerous. But I think that, again, this hearing is doing a very positive thing by putting a spotlight on it and by giving legislators a chance to question the special interest group that drafted the legislation that eventually passed, and for a change, looking back on it and say, wait a minute here, what the heck happened? Were people deceived? Were people misled? And that's all I hear people saying whenever I'm out talking about this issue. That's all they talk about is how they feel deceived, they feel misled, they feel that they were let down, and I think it's extremely dangerous when that happens and we just say, well, you just didn't read the fine print. It's your own fault. It was your fine print. You drafted it. You drafted it in a way to make sure that the people didn't know what they were actually voting on. So I appreciate very much you letting me testify on this topic, and obviously happy to answer any questions.
Are there any questions, Senator Angel?